The Buzz with Jess Lujan.
The plebiscite is our topic tonight. I have the Attorney General of Guam, Liz Barrett Anderson, and Julian Uggan, Attorney Julian Uggan tonight. We're talking about, of course, the plebiscite, Guam's plebiscite. Prior to going to a break, Attorney General, we were talking, of course, about the classification. I mean, the folks who are able to vote versus not, and it's not based on race, but on the date. Now, you were talking about the Voting Rights Act, okay? Now, you're as a layman, okay? So what the Davis argument is about, now it'd be valid if they were to deprive him from registering to vote for, say for example, this upcoming election, okay? Versus a plebiscite. So what's the difference again in those two? Even if the plebiscite were a definitive vote and something that's not just our expression or a desire, but if in fact this was a definitive, whatever prevails is the status that we're going to get, would that be any different if that were the case versus, of course, again, this election coming up where top 15, they'll be definitive, and of course other situations or other measures that may be on the ballot?
I like to describe it in terms of substance. Is it a substantive vote? Okay. Will it change something? Will it add to the law? Will it put somebody in office? Will it make a great change in your society and the government that you work under? That is a substantive issue, and every citizen has a constitutional right to a vote on substantive matters. The issue here is this is not a substantive matter. It's a political expression. But I'll be honest with you, Jesse. I'm here, and Julian is working as a Special Assistant Attorney General to defend this statute. And the legislature could tomorrow enact another statute and say, well, we want to do everyone's vote. So I understand Mr. Davis, and I understand those who express their discontent. Well, why am I not being asked? Madeline Berdalio cannot vote in this because she doesn't fit the temporal category. But yet our Congresswoman has done so much for this island. I would love to know exactly of the three options, what would her option be? So the disenfranchisement, or the sense of disenfranchisement, is understandable. What I'm doing is defending a statute in court in this litigation, and I believe we do have a very strong and a very viable motion for summary judgment. But we seem to be locked into this one little lawsuit. Why aren't there other remedies available out there?
No, absolutely. Now, Julian, some of the citations of cases that were cited, I think the Rice Cayetano case, all that. Now, how is that the argument? How is it relevant to this or irrelevant to this case?
I'm glad you asked that. Rice versus Cayetano is a case decided by the U.S. Supreme Court in 2000, and it arose out of a rancher named Harold Rice who sued the governor of Hawaii, then Ben Cayetano, for the right to vote in an election to install officers in a state agency. That agency was Office of Hawaiian Affairs. So at issue in that case was an election run by the state for the sole purpose of installing public officials into a public agency. Therefore, there's a clear analogy, a clear distinguishing. The case is so unlike this case. So the plaintiff relies so heavily on Rice while omitting several critical distinctions that make that case that case inapplicable in this case. For example, Guam is the plebiscite at issue is not trying to place, as the AG said, any public officer, any territorial officer into any territorial agency.
Or making any substantive change.
Or making any substantive legal change. If it were doing so, this would actually be an entirely different lawsuit. But this particular lawsuit is not amenable to analogies to Rice versus Cayetano because that case simply doesn't apply. And the 15th Amendment, that the U.S. Supreme Court explicitly held in that case that to deny that the plaintiff in that case to vote in that particular kind of state election was unconstitutional under the 15th Amendment,
Sure.
because it was an election within the meaning of the
Sure,
15th
sure,
Amendment,
sure, sure.
unlike this case, which is not.
Sure, sure.
Yeah.
To comparing apples to oranges, basically.
Yeah, and so we're essentially, like, the plaintiff does that a lot in the pleadings. Davis has drawn analogies or offered analogies to the court to consider, even civil rights cases, famous cases, brought in a very different historical context. So we are arguing throughout our pleadings that those cases are simply inapposite. They don't apply to the particular plebiscite at issue in this case.
Yeah. Now, even when let's advance forward, June comes, you appear before the before the court. Now, the previous AG as well has argued the fact that it's not ripe. There's really no date scheduled, and I doubt it that that June will come and there will be a date. I know the governor's pushing to 2017 to be a ripe year for a plebiscite to happen, but that's not concrete yet. We still have to get the educational process out. So there's no definitive date at this point. Previous AG had argued the fact again that they've talked about dates, they've talked about elections, but it's yet to happen. And I doubt it that June will come, and so that argument still be relevant. I think
it's been over. When was that passed? 1998.
Ever since.
Yeah, and we haven't had an election since then. I know one of the difficulties that the Election Commission has is meeting the standard of
the percentage, right?
The percentage, right?
Yeah.
And I have to, give the Election Commission a lot of credit. They are really making a strong push. So once they meet that, then there has to be a process for education, and then a process, and it's not cheap. I think this is going to be very, very costly. So it's expensive.
Yeah, no.
I wish Congress would just give us the money for this, because they gave the other island, you don't want me to mention, $4 million in the mid-90s to do their third plebiscite. They gave them $4 million. Wish they'd give us some
Well,
kind of
don't get me started on that, because was it they just passed the omnibus
the other
bill.
island?
No, the omnibus bill in regards to compensating the Iran hostages, former hostages, compensation, for that. And how about
you read through that entire massive bill?
But how about our war reparations, right? Yeah. So
that's not good.
Right?
Oh.
No, that's not good, right? That's another case you can argue about. But so anyway, come June, Julian, what do you expect now? Should we not prevail in this, and we have an opportunity again to go appeal this, right? To maybe even the U.S. Supreme Court. Knowing at this point that they're still more conservative than liberal in this, and because even some of the cases cited in regards to other cases not related to this, like the territories voting for president, they're still citing cases when the Supreme Court was really a racial court, or really racist, when they came out with opinions being heavily on the racial side. But quoting cases, our president is quoting cases from that, knowing again it's still the balance of the heavier-handed conservative side. Yeah. What are our chances? The arguments are good. You got
You're
great
talking about
arguments.
the Supreme Court?
Talk about U.S. Supreme Court.
Oh, that's not fair. Because a lot is involved. And you're right. We are a very diverse United States Supreme Court.
Yeah.
And I'll tell you, before we ever get to the doors or the stairs of the Supreme Court, we are going to be so well prepared, because the Attorney General's office and the National Association of Attorneys General help us to prepare very, very well. I'll tell you this, Jesse, if we, and you're right, my thought is we take it all the way to the Supreme Court, and I'm going to be very proud to be with this young man sitting there. I've been at the Supreme Court, and this was on the Narangas case when I was Attorney General before, arguing to protect the territory of Guam from civil rights lawsuits. And we were successful in the Narangas case. I sat there at the table, and I'm going to be very proud if we end up in the Supreme Court. I'm very confident in our motion for summary judgment, though.
No, I'm not saying that. I'm not judging, again, abilities or capabilities or not.
Oh, you're just saying
I'm
what
just saying,
happens if we
what
go over
happens
there?
if, you know, just the what is, and I think we have a strong case. But again, there are some things, you know, whatever their ideologies are, he is beyond our control, right?
He might have already been studying all the justice. He's doing his homework already.
If I could just add something,
Sure.
even before the U.S. Supreme Court, it's Ninth Circuit review.
Ninth Circuit,
and I'm
yeah,
quite
yeah.
confident because there's a line of precedent that's
Yeah,
really
yeah,
helpful to our
sure,
case.
sure.
The Ninth Circuit decided in the early 90s Wobble versus Villacrucis, and in that case, and that was also a constitutional case that was brought on the grounds that the land alienation provisions restricting permanent and long-term interest in real estate in the NMI to people of NMD descent was race-based and unconstitutional.
yeah.
And in that case, the court rejected the equal protection argument and said, no, it's not race-based because the Bill of Rights and first, because unincorporated territories are, they're unique. They occupy unique space within American constitutional law. So you can't just assume, legally speaking, that the Constitution applies in the way it would in other jurisdictions. And so that's the heart of our case and our defense in this case is that the insular cases, you know, where in some ways they often show up as the villain historically, but in this case, in some ways, they're not the villain because in the past, the U.S. Supreme Court and the Ninth Circuit has also confirmed consistently over decade after decade that an unincorporated territory is constitutionally unique. So therefore, we are constitutionally unique, and as long as the Guam legislature is not deviating from the definition provided by Congress itself, we're good. So that's the argument that Congress actually created the class.
The argument that Julian is just making is being made through other insular territories of how we are treated in terms of what are the arguments that apply that are applicable to states but don't apply to the insular territories. It's a completely different argument.
I got to take a quick break, but
Okay.
one of the episodes we'll be talking about, of course, is whether domestic or international